It's Entertainment Law Update, episode 185. And today is November 5th, 2025. Welcome. Hi, everybody. Welcome to Entertainment Law Update. It's me, Gordon Firemark from Los Angeles, California.
And it's me, Tamera Bennett from the Dallas-Fort Worth Metroplex.
You changed one little thing.
It throws us off. Hello, everybody. Back to you, Gordon.
Well, thank you, everybody, for being here with us, for joining us for this episode of our podcast. This is the podcast by entertainment lawyers about entertainment law for professionals in the entertainment industry, where each month we round up notable cases and news and information to keep you informed and hopefully a little entertained. We do welcome your feedback, your suggestions, your input, and your ratings, of course. So please do visit entertainmentlawupdate.com and use the voice widget on the side of the screen, or send us an email at entertainmentlawupdate at gmail.com. And we're really glad you're here with us. And I'm glad that you are back in this hemisphere, Tamera. You've been on a trip, haven't you?
I have, from Dallas to Honolulu, Hawaii by plane, then Honolulu, Hawaii, all the way to Sydney, Australia. 18 nights cruising through the South Pacific Ocean. That really hit me when I got an alert on my AirTag in my luggage that says, your luggage is no longer with you. It has been sighted in the South Pacific Ocean. So I texted Johnny and said, did you throw my suitcase overboard? Anyway, great trip. 3 stops in French Polynesia, which was amazing. You know, snorkeling, ATVing, all kinds of fun things there. Was not able to make our stop in New Zealand because of weather. So that was disappointing because I was ready to leave the ship. And then just because of scheduling, because we'd already been gone 21 days, we just were able to stay one day in Australia. But that is, in Sydney, Australia is my favorite, not big city. So I highly recommend that for anyone. But yes, we had a great time.
And did your cruise do the thing where it crosses both the dateline and the equator?
We did, not at the same time, but when we crossed the equator, they did a fun little ritual ceremony, which was fantastic. It was very comedic. And so that was really fun. And then we got a certificate for crossing the dateline, which was also very cool.
Neat.
And my husband loved it that college football was on Sunday.
Okay.
So there you go.
I just had this thought, maybe we should develop an entertainment law update fan and, team and friends cruise of some sort where we all go. And
we should
do a show live in front of an audience and all that. It might be fun. So,
yeah.
All right.
We would
look into that.
People might leave like I did on that one comedian. So I don't know. I think we're funnier.
Well,
anyway,
they know
Gordon and I were talking about funny comedians earlier.
Yeah, I just got back. Last night I saw Sarah Millican in concert. For those who don't know Sarah Millican, she's a very funny British comedian who her YouTube presence doesn't do justice to how blue her show is and how much language and vulgarity is involved. But she was very, very funny, and at the historic Wiltern Theater here in Los Angeles, and it was a terrific show. So we had a great time.
Oh, I've been to that theater. Yeah, it's amazing.
It's one of those Art Deco theaters in LA. There's 3 or 4 of them, and it's pretty amazing. It's been there a long, long time. So. Anyway.
Yeah, when we were there, all of the people were having the valets pull up their town cars and limousines, and our rental ended up being a Volkswagen Bug. So anyway, that's just also par for the course for my life.
That's great. Well, let us get to our content of our show for today, and we'll start off with a follow-up from quite a while back. You may remember a couple of years ago, we reported on the case of Price versus Garland, which originally started as Price versus Barr when Bill Barr was the Attorney General, but Garland took it over before the case was heard by the upper courts. Anyway, we reported on this case, a legal challenge by independent filmmaker Gordy Price against the National Park Service over the permit fees that he was charged in arrears for having filmed on public lands. And he argued that that permit and fee requirement for commercial filming violated his First Amendment right to free speech. Essentially, that it was a tax on speech, and beyond the power of the agencies to impose those fees. In 2021, he succeeded in district court, which agreed with him, finding that the regulations were unconstitutional and declaring filmmaking a constitutionally protected form of expressive speech. And then in 2022, the appellate court, I think that was the D.C. Circuit, reversed the district court's decision, stating that filmmaking is not inherently a communicative activity, and that, which is weird, and that the regulations only needed to meet a reasonableness standard. So I guess, what's that called? The rational basis test. And this meant that the National Park Service could continue to charge permit fees for commercial filming. Well, yesterday I had an email from Gordy Price, the filmmaker in question, telling me that he has made a documentary about the case and about some legislation that followed it. And somehow we missed this legislation when it was enacted back in January. There's kind of a lot going on back in January of this year, but the act is called the Explore Act. It was signed into effect in January of 2025 and created a new legal framework for filming on federal lands. That legislation modernizes the policy of the outdoor recreation and the agencies that regulate this, and includes provisions for filming and photography on federal lands. Essentially, the act restricts the authority of the Secretaries of the Interior and the Agriculture Department to require permits or fees for filming activities that involve fewer than 6 individuals or are just incidental to other authorized activities. Directs the secretaries to create a fee-free de minimis use authorization for these kinds of activities when there are fewer than 6 to 8 individuals, is what our notes say here. So the act does still allow for commercial permits to be required and fees for filming activities that are going to bring a lot of people, have a significant impact on the park resources, and so on. So if you're not already aware of this statute, now you are. So you want to check it out. It's the Explore Act. And a big thank you to Gordy Price for bringing this to our attention. We actually have links to the trailer and the documentary for his documentary in our show notes at entertainmentlawupdate.com/185. That's this episode number. So that's pretty cool.
I look forward to taking a look at his documentary. I suspect the Explore Act has specific language related to drones, because that probably is something that's been limited as to how they can be used or what permits or permissions you need.
And that brings in yet another federal agency, the FAA, right? So, it may be that this is just targeted at the interior and the agriculture. Was it that? What was it? Interior and agriculture?
I think so.
Yeah. So, we'll see. But, a positive step out of Congress in 2025. Who knew?
Yeah, a step out of Congress.
Yeah, really. Of course, it was. I suspect this was signed into law before the new president came in. So anyway, I didn't look up the exact dates, but
the exact date of it, yeah. So we've talked about a bunch, and even last month about the Anthropic settlement that was approved. So Anthropic has its settlement approved by the federal courts because there was some question, were they going to approve it or not? A lot of this settlement has sparked criticism. As we discussed, it's the largest copyright infringement settlement in U.S. history, perhaps in the world. And I don't know if that's too broad of a statement. While Anthropic has agreed to pay $1.5 billion to authors, they're only going to receive $3,000 per work. There's a very short time frame for each author to confirm and prove up their work was infringed. And to do that, they have to check an unpublished confidential list, which I think that's a big part of the concern is, how are we settling this and saying this list is confidential?
Yeah.
Derivative works are not addressed as part of the settled claims. So, what happens if an output,
Right.
authors can still, copyright claimants can still assert that a derivative work was created. And it's interesting. This is me thinking,
Yeah.
well, if my title was on that list, I can definitely prove access, can't I?
Mm-hmm.
In my derivative work claim.
Right.
So, yeah.
Except it's a confidential list, right?
Except it's a confidential list. But, there's always, anytime you do a settlement, there's kind of this, it's confidential unless you need to prove it up for litigation or ordered by court kind of statement. So surely that's in there.
Where there's a will, there's a way.
Yeah, that's right. So one of the commentators, I believe this was the Music Tech Policy blog, brought up, what about federal copyright infringement? Could we have a federal prosecutor take enough interest to bring a criminal copyright infringement claim? This is under 18 U.S.C. Section 2319, referring to willful infringement of a copyright for commercial advantage or private financial gain. I wrote a whole memo on this section of the law in 1997. Should I dig it out?
Sounds like a plan.
Sounds like a plan. That was a long time ago. Penalties vary based on the severity of the offense, but can include claims up to $250,000 and 5 years of imprisonment. Is that going to happen? Probably not. Is it an option? Sure, it's there. But we'll, anyway, take a look at the notes we have and the links we have in the show notes to kind of get a better feel for some of other arguments, and then again the issues that both content creators, content owners, and I think AI companies are raising related to this settlement agreement.
Absolutely. Well, still on the subject of AI, we have Stephen Thaler, the computer scientist whose case has so far sort of been the groundbreaker on the question of whether or not works that are output by the AI system without traditional direct authorial contribution by a person can be protected under copyright law. And in October of this year, Thaler asked the Supreme Court to reconsider lower court rulings that a work of art generated by AI can't be copyrighted under U.S. law. He argued that denying copyright protection for that artwork made by his AI system would create a chilling effect on anyone else considering using AI in a creative endeavor, and that it defies the constitutional goals from which Congress was empowered to create copyright. That's interesting. So Thaler's from Missouri, St. Charles, Missouri. He applied for copyright in 2018, covering his piece titled A Recent Entrance to Paradise. That was generated by a system he built called DABUS, Device for Autonomous Bootstrapping of Unified Sentience. Sounds like something an artist would call his work, doesn't it?
Yes.
The Copyright Office rejected that application in 2022, and then finding that the creative works have to have human authorship to be copyrightable. And since then, every court that's addressed the question has agreed with the Copyright Office, and a federal district judge in Washington upheld the decision in 2023, saying that human authorship is a bedrock requirement of copyright. The D.C. Circuit affirmed the ruling, and so now a petition for cert to the Supreme Court. So as of now, human authorship is still a requirement. The U.S. Copyright Office has issued guidance on the subject, saying as much in dealing with works containing material generated by AI. And it has granted some copyrights to works that were partially generated by AI, but only insofar as the human authorship went. And the single piece of American cheese is the piece in which the author was able to show significant human input. So now, he had previously petitioned the Supreme Court in April of 2023 based on similar facts, but in a patent case. That case was called Thaler versus Vidal, and Thaler asked the court to consider the question, does the Patent Act categorically restrict the statutory term inventor to human beings alone? The Supreme Court denied cert in that case, meaning it wouldn't review a lower court's ruling that had affirmed that inventor must be a human under the Patent Act. So we'll see what happens in this case with the Supreme Court having yet to rule on certiorari in this case.
Right. Right. We got a couple of more quick takes on AI. Lawyers, once again, are they hallucinating? Because the AI is definitely hallucinating.
Yeah.
This is a case out of the California Court of Appeals, just recently issued. Counsel in California suffered a tough lesson in AI usage. That's an understatement.
Expensive.
In an appeal to the Second Appellate Court in California, plaintiff's counsel utilized generative AI to draft its brief, and the majority of the quotes and case citations were hallucinated by the AI system. This was like second or third strike because many of those quotes had also been hallucinated in his lower court filings. And the lower court pointed it out, and he or she, I don't know if it was a man or woman, did not correct those. And because of that, when the court sanctioned him to pay the $10,000 in sanctions, they went into the court clerk instead of to the opposing party. And the court went on to say, we publish this opinion as a warning because it's not something that the facts other than the generative AI would be something the court would have published. Simply stated, I'm quoting here, no brief, pleading, motion, or any other paper filed in any court should contain any citations, whether provided by generative AI or any other source, that the attorney responsible for submitting the pleading has not personally read and verified. These actions violated a basic duty the counsel owed to his client and the court. So there's a monetary sanction. This paper, the court's ruling, has to be served on his client. And the clerk of the court will be serving a copy of this opinion to the California State Bar.
And we'll see if that leads to anything, any discipline. Right. Yeah.
We'll see. We'll see.
I mean, this doesn't strike me as being anything groundbreaking. I mean, leave out the AI and just assume the attorney had just fudged a bunch of citations. That would be an ethical violation, probably grounds for sanctions and discipline. So, the obligation is to know what you're filing with the court and know that it's accurate and a valid legal argument. Bottom line. Right.
Verify those citations. The case exists, and that exists for the purpose of what you've cited in your brief and anything you file before the court.
Fact checking and cite checking. Isn't that what we all learned in law school?
Yes, we did. And we don't even have to go use books now. We can use the internet and make sure we get it from a verified source.
Absolutely.
To confirm that it's correct. Yeah. So that's our practice pointer. One of the practice pointers we'll have today. Also in our AI corner is, this kind of ties back into our conversation about what's protected by the copyright from an AI standpoint. ASCAP, BMI, and SOCAN, they are the three largest public performance rights organizations, ASCAP and BMI in the U.S. and SOCAN in Canada, have come together and issued a press release on October 28th, 2025, announcing they have each adopted policies to accept registrations of musical compositions that are partially generated using artificial intelligence tools. They can now be registered directly with those individual societies. All three PRO policies define a partially AI-generated musical work as one that combines elements of AI-generated musical content with elements of human authorship. Again, we're only talking about the song, the music and lyrics combined together. These works will now be included as part of the full repertoire of these societies. Musical compositions that are entirely creating using AI tools are not eligible for registration with each society. Again, the policy alignments among these three major North American PROs reflects the fact that songwriters and composers increasingly and often incorporate AI tools into their creative process. So there has been some misreporting of this in the news because instead of using the acronym SOCAN, which is for Canada, people have included CSAC, which is the third largest performance rights organization in the U.S. That is an incorrect report. SESAC and GMR, Global Music Rights, which are the two other performance rights organizations in the United States, I could not find that they have joined this statement or what their current status and policy is on AI generated works. BMI does go on to make a statement on their website that the works have to meet the U.S. Copyright Office's standard for the minimum threshold of human creativity. Okay. Is BMI going to make you submit your issued copyright registration certificate before they register the work? I don't know. I mean, unless they've changed their online submission, I don't know. Have they added a box that's going to say, is any of this created by AI? And you've got to click the box and disclose it. I don't know.
I was wondering as we were talking about this, but, is BMI, ASCAP, SOCAN, are they now going to become the arbiters of truth for, for how much authorship, what's the threshold and how many?
I don't know. And I need to speak to a colleague within those organizations and see, what have they changed as far as submission?
Yeah. Well, maybe one of our listeners
historically, they are not the arbiters of truth, right? Because if you need to make a counterclaim saying, oh, hey, that's the wrong claimant there, right, the money should be going to me, you notify them and they say, we're not arbitrating the truth. We will just freeze all payments.
Yeah.
You guys go arbitrate the truth and then come back and tell me. And having clients on both ends of that conversation, I get it.
Yeah. I also find myself wondering, are these ASCAP filing these registrations with the PROs going to become evidence in other copyright cases? Because, you admitted that, that you didn't create that part, or there was, I could see defendants.
Practice pointer number 2, yeah. If you're in one of these cases, ask for that in discovery.
Yeah. Yeah.
So that's another way to prove things up. Anyway, all of these performance rights organizations advocate for music creators to be fairly compensated. And then BMI goes on to say, we also advocate alongside the freedom to create using the tools of the creator's choice. So I thought this was interesting. I did go out and look for SESAC or GMR's statement and was unable to uncover it. Again, if somebody, one of our listeners has some more insight, please.
Well, that language also about using the tools is important. That's something we haven't heard a lot of discussion about, but these are tools that can be used creatively. That's the argument for allowing works when you can show enough human creativity and going into things. I think it is the future. Everybody's using AI for one thing or another these days. And why should artists be deprived of an opportunity to make money and earn a livelihood from having, just because they've used these tools? So, so step in the right direction, I think.
I don't know. It's a step. I still struggle with it. I struggle with it. I mean, I look at, we're going to talk about another case where, as to what was protected in a copyright registration.
But first, still on AI, let's talk about the new law in California. It started out as Senate Bill 53, signed into law by Governor Gavin Newsom on September 29th, the Transparency in Frontier Artificial Intelligence Act, TFAIA. Also, we're going to refer to it as the law. The government stated in his press release that the law is the first in the nation frontier AI safety legislation that builds public trust as the emerging technology rapidly evolves. The goal of this act is to protect against potential catastrophic risks from frontier AI developers, requiring them to report on their safety testing and risk mitigation strategies. The law mandates that large developers of these advanced AI models publish safety testing reports, establish safety frameworks, and report critical safety incidents that could cause significant harm. It also provides whistleblower protections for employees who report concerns about these systems, and it includes civil penalties enforced by the California Attorney General for noncompliance. So, first of its kind law. I'm not exactly sure what a frontier AI thing is, but the law does a pretty decent job of defining it. So
I'm guessing that's a nod to the Wild West.
Oh, yeah.
Kind of, or the space, the new frontier of AI,
Right, exactly. Yeah.
Maybe that was automatically part of what everybody else picked up on, not so much me.
And, California historically has been pretty privacy conscious about, privacy concerns, rights of publicity, the AI tools that are generating images based, likenesses of real people, those kinds of things. So setting up some guardrails here, I think, makes some sense. We'll see if this law works. We'll see if this law passes constitutional muster. I'm guessing there will be a challenge before too long from someone.
Well, and if it does pass, will the Attorney General enforce it?
Well, yes. Good point.
Yeah, I mean, that's just what we'll have to see. Yeah. So I on this one, I do agree. Step in the right direction. So right. There we go.
Well, we have this case. Go ahead. Sorry.
Well, no, go ahead.
We have this case involving French Montana and a kind of tricky ruling to navigate. The case is called Richardson versus Carbach. I don't know. Eddie Richardson versus French Montana. Teenage producer, a hit song, and what it really means to copy in the digital age is really what's going on here. Did Richardson have a valid copyright registration certificate issued for the sound recording or for the sound recording and a musical composition? These are some of the questions. So this is a case where Richardson was 16 years old when he uploaded one of his homemade hip-hop beats, Hood, Push, and Wait, to the internet under his producer name, Hotwire the Producer. Great name. The track had everything: a heavy beat, rhythmic snare, melodic flow, and a digital tag calling out his name. And then a few months later, he heard what he thought was the same beat blasting from radios everywhere in French Montana's breakout hit, Ain't Worried About Nothing. So obviously we have the law that says there are two different copyrights in every sound recording: the sound recording itself and the underlying musical composition. Richardson ends up suing French Montana. This started in 2019. Hard to believe it's a 6-year-old case, but he was claiming a copyright infringement under Section 501, and in the complaint, he attached an exhibit, the copyright registration certificate from May of 2013 for a collection of unpublished work, including this one. And it was the registration was an SR registration for sound recording, production, and music, and did not include lyrics. So he asserts that the allegedly infringed track is part of this collection of unpublished works, and then goes on to assert that between October of 12 and April of 2013, Carbach, which is French Montana, and his agents accessed the track from SoundClick or other users of SoundClick and other websites and apps that may be linked to SoundClick. Sounds like there might have been an evidentiary question there too. But in April of 2013, Montana published, performed, and widely distributed Ain't Worried About Nothing, which the plaintiff calls a derivative work of his work. So the melody, and exclusive of the lyrics and vocals, is nearly identical. Interesting. You want to take over here, or you want to just?
Sure. So those were all allegations pulled from an amended complaint filed by the plaintiff. Montana, I'm sorry, the plaintiff is obviously looking for profits from live performances. I would assume also from all distributions of the recording made by French Montana, as well as was asking for an injunction related to the sound recording. I will kind of plug in a couple of oddities that's going on here. And I got sucked into reading Pacer today and going through all of the various filings, because what's confusing factually in the opinion issued by the court is whether or not there was a claim for copyright infringement for the sound recording created by Richardson and or the underlying musical composition, which did not include lyrics, just the musical part, the beat, the track, the rhythm, the melody created by Richardson. And I think not only I was confused, But unfortunately, it sounds like all the lawyers involved were also confused in how it was initially pled in a way that made me think it involved both the sound recording copyright and the musical composition copyright. But yet the evidence that was submitted seems to have only been related to the sound recording. So anyway, the defense, Montana's lawyers pushed back and said there was no sampling of Richardson's sound recording. While the two tracks, again, the sound recording sounded similar, imitation is not a copyright infringement. And again, the U.S. copyright law protecting a sound recording copyright protects the actual recorded sounds. And I'm going to put a big asterisk, but deviation here, unless the music or musical composition or lyrics are claimed as part of the sound recording copyright, which they can be, that copyright registration isn't going to protect the song, the feel, the idea. What's never going to protect the feel, but the musical composition can be protected. So defense goes on to argue, we didn't copy it. We just recreated something that sounds like it. Okay.
Isn't that what copying is?
Well, I think it is, but the court went on to talk about that as to, and this was a question of first impression, that as to the copyright for a sound recording, unless you actually sample it, meaning you snipped out that bite and incorporated it into a new sound recording, there is no infringement of the sound recording. I think that is correct. Now, the court also said we're not going to address how much of a, is it 3 seconds? Is it 10 seconds? Is it 1 second of what you might sample as to how this applies? But what we're telling you is we did not see evidence, either testimony, physical evidence, expert witness, that would lead us to believe that there was actual copying of the sound recording. But in the middle of the briefing, the defense casually mentioned what is, I believe, a crucial legal point that led me down the rabbit trail of reading everything in Pacer, and I didn't get to read it all, that Richardson only held a sound recording copyright and not a musical composition copyright. But that is not correct, based on the copyright registration submitted with the amended complaint. Now, what I don't know is how or when or what got submitted into evidence in the trial. And I don't know. It was part of an unpublished collective work. So he may have submitted, 10 tracks.
Right.
And this was part of one of them. So anyway, it was messy all along. Evidently, everything that went into evidence and was argued related only to the sound recording copyright registration. So the court's ruling had to be based on the facts submitted into evidence. And so maybe Richardson could have recovered as to an infringement of the musical composition. We don't know. Is that practice pointer number 3 for this episode? Make sure you know what you're arguing and what your copyright registration covers.
Yeah, be clear about what's the work in question, really. Yeah,
that's right. Be clear about the work in question. There was also issues about neither one of the plaintiff or defendant properly complied with local rules, and what's good for one is good for the other. So on some procedural rights, but in the end, the court said sounding alike when it comes to a claim of copyright infringement of a sound recording is not sufficient. You've got to show that you actually copied the sound recording. A new recording that mimics the copyrighted one is not an infringement so long as there was no actual copying. So French Montana wins, but the court does not award that party attorney's fees. So it was a summary judgment for French Montana was affirmed. Richardson, the plaintiff's injunction request, was denied, and attorney's fees were also denied. So I just think this is a great case if you're dealing with a copyright infringement claim, plaintiff or defendant. that involves, that you question. Does it involve the sound recording? Does it involve the musical composition? Does it involve both? I would dig into everything that got filed in this case, and be very careful how you not only what you plead, but what you put into evidence.
Yeah.
The expert testimony did not get into evidence what needed to be into evidence for the plaintiff.
Yeah, I mean, it sounds like a rookie mistake, but maybe there wasn't the evidence that, well, who knows? I mean, that access question it sounded a little tenuous from, what I was reading in the early part of the summary. But anyway, it sounds like, well, it's worth a deep dive if anybody wants to better understand the nuance of what went on in this case. It's Richardson versus Carbuck. That's KHARBOUCH, and should be able to find that if you go looking, and probably worth a deep dive. So
yeah, and you talked about it's been going on for 6 years. One of the things I noticed, because I was in Pacer, is this was, and we talked about it was filed in 2019. Court COVID procedures in 20 and 21, I think probably is a big point. Part of what slowed this case down. Does that play into the outcome? I don't know, but it was clear that it was happening during that time period.
But it also sounds like the plaintiff waited 5 or 6 years before filing the suit after learning of the
and that also was argued as to what could have been his damage recovery based on the delay in filing the suit.
So 12 years start to finish from the infringement to this unfortunate, this difficult ruling. So anyway. Yeah. Well, you remember a couple of years back, we talked about the secret Wu-Tang Clan album they only made the one unit and they sold it. It was Martin Shkreli, that sort of disgraced drug company guy. He was the original buyer of this. He's the pharmaceutical executive convicted fraudster. He purchased the album, Once Upon a Time in Shaolin, from Wu-Tang Clan, and it was a big news at the time as a single issue, limited edition kind of a work. Well, I think it was in the bankruptcy, or there was a forfeiture as a result of the fraud conviction, and the album was purchased by a successor. Pleasure Dow, I'm going to say, is the way we pronounce that.
I'll go for that.
So the allegations in this case that we're talking about today are that Shkreli allegedly unlawfully retained and distributed copies of that album. And after the sale to the successor, he still played the work during live streams and admitted keeping multiple copies. He even said that he would send MP3s to anyone who asked, and to various women that he was interacting with, and streamed it publicly and so on. Now, here's the thing. The purchase agreement contained a number of interesting provisions. First off, when Shkreli bought the work, he got 50% ownership of copyrights and renewal copyrights. Is that a thing? Renewal copyrights? Shkreli could duplicate the work, but only for private use. But only for 88 years he was not allowed, but for 88 years, he wasn't allowed to duplicate, replicate, or exploit the work for any commercial or any other non-commercial purposes other than that sort of private use. So he was allowed to play it in the buyer's home, museums, galleries, restaurants, bars, that kind of thing. He was also allowed to sell the work to a third party on the same terms as the original purchase. And when he paid $4 million for it, he was restricted. So it was a forfeiture order. And that restricted him from taking any action that would diminish or damage the assets that might be used to satisfy the forfeiture order. So the plaintiffs purchased the copyright as well as the work itself, as the physical goods, and brought action for enforcement of this forfeiture order. Violations of the Defend Trade Secrets Act, that's interesting. Misappropriation of confidential information and trade secrets, tortious interference with economic advantage, unjust enrichment, and recovery of chattel. So trade secret becomes an issue. Counts 2 and 3 relating to the trade secrets were by the court deemed plausible because the plaintiff sufficiently pled that the works were a trade secret. They met the requirements to be considered a trade secret. That is broadly defined, but the court looked at this 6-factor test, 6 guidepost factors, you could say. The court noted, yes, this is unusual. The trade secret is an unreleased album, but since trade secret included all forms and types of business information, so long as there were reasonable measures to maintain secrecy and independent economic value, then it could be a trade secret. And the court said that the defendants seemed to concede that point, that this could apply to the album. And then it went into the analysis of whether it is a trade secret. They determined that the contents of the album were generally unknown. There were measures in place to guard the secrecy of the information, that the album had significant value, at least $2 million, is what it said. And that was because of its secrecy, and that it was actually kept as a secret. The court noted that other circuits looking at state law determined trade secret protection might not extend to unreleased musical works. There's a case involving Prince, the Paisley Park Enterprises versus Boxill.
And we need to go back and look at that, because I'm sure we talked about it.
I'm sure we did
in 2017.
Yeah,
we'll have to see if we've changed our mind.
And then another case, Anderson versus Jackson, ruling that an unreleased Janet Jackson song had no value due to its secrecy. I think the difference here is that the fact that it was a secret, 1 unit only, limited edition thing was very public. So the value came from the secrecy in that instance. Whereas the Janet Jackson thing, well, it hasn't been released yet, so nobody knows about it, so it doesn't have any value until it's on the market.
Sure. So you've got this body of work that is, as we call it in the music business, on the shelf.
Mm-hmm. Great question.
Somebody gets, and in many cases, when I'm saying on the shelf, it's works that have not been digitized. I mean, it literally may be the 2-inch tape on the shelf for some of these.
Right.
Yeah. And if you don't know what I'm talking about, then you're too young and I'm too old. So sorry to our younger generation. Tape? Ampex 2-inch tape on a shelf? What does this mean? So anyway, so if we get into the vault, the physical vault with the 2-inch tape on the shelf, maybe it's not a trade secret because it was just stored and not secret, but yet it could very well be a copyright infringement depending on what someone were to do with that.
Well, I wonder if you had, let's say, some prolific songwriter had a bunch of unpublished, handwritten lyrics and songs, that they never put out, never released, kept them in a safe. Somebody broke into the house, broke into the safe, got those, and then published them. Not only is there a copyright infringement, but because they were kept under lock and key, because they were not made available to the public, does that make them a trade secret? The court here seems to be dealing with a very unique set of facts. It did strike some of the other claims in here, the forfeiture order thing, because there was no standing by the purchaser. Tortious interference and unjust enrichment were preempted by copyright law, but the trade secret claims were different and separate enough to be allowed to continue. So, here's another hypothetical. Thank you, John, for this. Say a random employee of Warner Brothers obtains copies of the Batgirl movie that was never released, right? And that person then throws a watch party or disseminates the movie to the masses. Would that be a violation of Warner Brothers trade secrets? They made a business decision not to release this film. Presumably it's under some kind of lock and key equivalent. Mm-hmm. But, if they're not going to release it, then does it have any commercial value? Does that make it a valuable trade secret worth claiming? I don't know. This is an interesting scenario.
Well, and I mean, trade secrets always, I won't say always. My understanding that trade secret law is contingent on a factor that it has to give you a commercial advantage.
Right.
That is key. And So I don't know. I mean, I think that's what we need to be thinking about if we're trying to apply this argument. I mean, I love that it's not preempted by copyright. If you can prove this claim, because it's should be a separate damages assessment, or at least it's a separate cause of action. Maybe you can't recover twice, but yeah, I don't know. And so the hypothetical number 2 that I believe John gave us was a famous author writes a novel concerning 2 lab mice that try to take over the world as part of a long-running series. He keeps a singular copy of the book on his computer to draw attention to in writing. He sells that singular copy, including an assignment of any copyright interest, at auction, on condition that the buyer cannot publish the book for a period of years, cannot publicly display or disclose the contents of the book, and must restrain subsequent purchasers. Well, this sounds a lot like the facts, the existing case. After reading the book, it's sold. If the purchaser reads the book on a live stream, could the subsequent buyer make a claim that it would be a violation of a trade secret law? Potentially, yes.
Yeah.
I mean, because I think that more aligns with the facts of this particular case. I think this is a very fact-specific case.
Well, yeah. I mean, I do think that there are scenarios where, like, for example, what about a TV show or a movie where the ending has a twist that doesn't get revealed? You know, that you keep the outcome.
Oh my gosh!
Who shot JR?
Well, it took us a long. But what about the worst case scenario for a fan of a TV show? You got a cliffhanger. You get a cliffhanger. No, not a spoiler.
Right.
You have a cliffhanger, and then it doesn't get renewed for the next season.
Yeah.
So what happens in that situation if maybe they've already filmed the next season or several episodes, and then the cliffhanger is revealed in something that's already been filmed, and then that gets released?
But the economic value of we're not releasing it yet because we're going to wait till next season, or nobody's going to know the ending of this movie until it's in the theaters. And then if that information is revealed, then that does seem like trade secret because it does have value. We're stimulating interest and consumption by making the scarcity happen.
Yeah.
So, yeah, interesting. It probably not a wide-ranging impact of this particular case, but it's an interesting twist. And kudos to the lawyers who came up with the trade secret theory.
Yeah. Well, and I'm going to see if I can talk to my friend Joe Cleveland, who is an attorney here in Fort Worth. He is like the expert on trade secret things. And I'm going to see what he thinks about this and pick his brain. If we've got anything new to add, I'll bring it up, or see if Joe can join us.
Great. So a little easier to get our heads around this case. Gibson versus Armadillo Distribution Enterprises. Gibson Inc. is the guitar maker. And this was a long-running now trademark infringement case dealing with the shape of the guitars put out by Gibson. After an initial verdict in Gibson's favor, the Fifth Circuit had reversed and the matter was remanded. And the new jury still largely found in Gibson's favor, saying that there was intentional infringement of 5 trademarks. There was no infringement on one, and one that should have been considered generic. I wish I'd gone and looked that up to which one was generic, but anyway, I suspect I know. But anyway, the jury also found in favor of Armadillo regarding its defense of latches, but determined that Armadillo still had unclean hands in connection with its infringement. And then the jury awarded Gibson $1 in damages. Didn't complete all of the verdict form regarding statutory or exemplary damages. So the court awards $169,000 in disgorgement of profits because of the intentional nature of this infringement. But that's it. So $169,000 doesn't seem like, I mean, that probably consumed by attorney's fees.
No, it didn't cover the attorney's fees. There's no way.
Yeah. So
a tenth of the attorney's fees, maybe?
A Pyrrhic victory. Well, we may see a claim for attorney's fees still, but it feels like a Pyrrhic victory to me.
Yeah.
And, but still, it's important to, hold these infringers accountable for knocking off the Gibson guitar look and feel.
Yeah.
So, yeah. And another one that just won't die. The Nirvana baby child pornography lawsuit. You take this one.
Okay, so we have covered this case many times over many years in multiple episodes, but more than 3 decades after Nirvana released their album Nevermind, the federal court battle over its iconic album cover has, we believe, finally come to an end. On October 1st, 2025, the U.S. District Judge granted summary judgment in favor of the defendants and dismissed with prejudice. Maybe that is the end.
Mm-hmm.
Dismissed with prejudice the long-running lawsuit filed by Spencer Eldon. He is now a 34-year-old man who he appeared nude as a baby on the cover of this album. As we've also discussed, I do not believe that version of the album cover has been in public circulation for a long time.
Mm-hmm.
So I don't remember exactly when that ended. But anyway, he sued in 2021, alleging the photographer and Universal Music knowingly produced, possessed, and advertised commercial child pornography when they used the underwater photograph of him as an image that was taken in 1991. His father accepted $200 as payment to allow his 4-month-old son to participate in the shoot. The plaintiff claimed that he had long-term psychological, reputational harm and that he was entitled to damages. In the decision, the judge conducted a point-by-point analysis of the allegations and the undisputed facts and focused heavily on the intent and context of the photograph, including the presence and consent of Eldon's parents at the time. Concluding there was no sexual purpose or lascivious content, the judge stated, quote, that the album cover is not child pornography. The court was allegedly or stated equally skeptical regarding the claims, and partially because Eldon referred to himself as the, quote, Nirvana baby, posed for recreations of the photograph. He even tattooed, I didn't know this, tattooed the word Nevermind across his chest. And at one point he sent a thank you note to the photographer. So anyway, the lawsuit at last dismissed with prejudice means he cannot refile the claims. And this marks the second time the federal court has thrown out the case. There's been 4 years of litigation and public scrutiny. Now, this is probably one of the most enduring images from the 1990s for a very influential album. And it's a feature, I think it's right. The court affirmed it's a piece of cultural and artistic history, not a crime scene.
So, I guess he could appeal, but when we don't have, this is a trial court level ruling, but.
Oh, that's right. It is.
Yeah. But
so it may not be finished.
Well, we'll see. We'll see.
I
don't know. I think this guy's made the most of his 15 minutes of fame for sure. 34 years of fame, but, hopefully this is concluded now. Let's not. It's easy to label things as pornography, child pornography, and tug at the sympathies of many people, and rightfully so. But this is just not that kind of a case. Nobody looks at this thing with a prurient interest. The sexual component is just missing. It's a kid in the pool. Anyway. Our next case is another quick follow-up. Conservative commentator Alex Jones has lost his appeal of that $1.4 billion verdict concerning false claims about the Sandy Hook shooting in 2012. Jones had been a denier of the Sandy Hook shooting and accused parents of theatrics, I guess you could say, around this drama, and enhancing the drama. There was even some talk about paid testimony in that. Anyway, Alex Jones's second request for an appeal, with the first claiming that he was improperly held liable for defamation, and the second concerned a request to pause the judgment against him. Notably, the other side of the case didn't even file an opposition to his request for review, and the court just denied it. So that's the end. Denied cert by the Supreme Court, and this one is the end of the case. So,
yeah. So we've got just a quick update about Drake losing Just Like Us litigation against Universal Music Group. On October 8th, the U.S. District Judge dismissed Drake's defamation claim against Universal Music Group for its release of Kendrick Lamar's Grammy Award-winning sound recording track song Not Like Us. So if anybody that's listening attended our Entertainment Law Institute CLE back in September, one of the speakers did a CLE presentation regarding this battle. So you may want to go back if you attended, but maybe didn't watch that CLE, watch it. Because it was very interesting conversation about how this was all set up, why he sued UMG and not Kendrick. But anyway, the defamation claim has been dismissed. I think our biggest disappointment as attendees of the CLE is that the presenter was unable to actually play the sound recordings because of the language. So we're like, okay, I'm thinking, are we getting it? Are we getting it? But anyway, we weren't able to hear that. But anyway, if you were part of our audience, go back and listen to her presentation. And the defamation is not found in the rap battle.
Okay. Well, that is about it for this episode. I just want to say to our listeners in California, all of those of you who are waiting for your bar results that come out in just a couple of days here in California, good luck. We hope it goes the way you want it to. Is there any other way? We hope you pass.
That's right. And I don't know when our Texas results come out, but it's usually right now because you just reminded me, because November 7th is my anniversary of passing the bar.
Okay.
So thank you for reminding me of that event.
Back when I took it, the results were released like the day before Thanksgiving. Okay. And it wasn't something there was online, but it wasn't something everybody was using. So you actually went to someplace to read the results to see if your name was on the list. And I guess it was published in the paper, but
my girlfriend who worked for the prosecutor's office, they got an advanced copy. So she called and told me. Anyway, best of luck to everyone across the United States as you wait for those results.
And that does it for this episode of Entertainment Law Update. As always, a big thank you to our loyal listeners for spending your time with us. And we do appreciate your feedback. So once again, head over to the voice widget on the website at Entertainment Law Update, or send us an email, entertainmentlawupdate@gmail.com. And Tamera, tell folks how to reach you.
Yeah, you can find me most social media at Tamera Bennett, TamerABennett. You can reach me at my law firm's website, harperbates.com. You can reach me at my blog and other updates at createprotect.com. Gordon, thank you for putting this all together and working with all of our tip-top team of contributors.
Right on. And our next episode, just for folks who are interested, we'll be doing our year-end roundup of the top cases, our totally unscientific approach to which are the top cases. And we look forward to that in our early December episode. And I'm Gordon Firemark. I'm in Los Angeles. My website is at firemark.com. My email address is gfiremark@firemark.com. Most social media has me down as gfiremark. And I want to say a big thank you and shout out to our team of volunteers who help and contribute to each episode. Managing editor John Janicek, Charles Thorne, Alexis Allen, Violet Zhang, and Dawson Holder all contributed to this episode, and we appreciate their help and their participation in all this. And listen, if you are interested in joining the fun and becoming a part of this little ELU family we've got, reach out to us. entertainmentlawupdate@gmail.com is the place to send a quick cover note and a resume, and we'll be in touch. And that's going to wrap it up for this episode of Entertainment Law Update. Thanks again for listening, and until next time, that's showbiz.